Good morning, everyone. Welcome to our HHQ webinar. We are glad to have many esteemed attendees with us today for our webinar on effective dispute resolution in the construction sector with insights on PAM 2006. Okay. Discussion on the lending and securities by financial institution. Before we kickstart this section, please be informed that all participants will be muted, and if there are any questions, please type in the Q&A chat box and we will discuss them during Q&A section later. Please allow me to introduce our speaker, Ms. Siang Li. Ms. Siang Li is a partner of Halim Hong and Kwe. Her areas of practice are corporate and finance. Siang Li mainly specializes in the area of corporate banking and advises various banks, financial institutions in a broad range of legal issues on the loan documentations, security documents, compliance matters, requirements, and procedures. So please join me to welcome our speaker, Ms. Siang Li.
Thank you, Kwai. Hi, good morning, everyone. I'm Siang Li here. Thanks for joining the sessions today. I'll be the speaker on the sharing of lending and securities by financial institution. The topics to be discussed today would be the general principle on the bank lending and financing, the securities usually accepted by the bankers and financiers in granting the loan facilities, particularly on the real estate, land, property, debenture, guarantee, and other miscellaneous securities that I'm going to talk about will be on the cash deposits, subordination, insurance policies. And I will also touch on the releasing of securities upon full settlement of the loan or credit facilities. And last part will be on the enforcement of securities for the recovery of secured debts. The general principle of lending and financing in Malaysia is that the lender or the banking institutions in granting a facilities or to accept a collateral as a securities, they will need to know how their companies or the bankers can be protected in the event the loan or credit facilities are in default. So basically, in most of the loans granted by the banking facilities to the borrower in Malaysia, usually they is supported by a loan documentation. So how does a loan documentation being drafted? There is no specific legal requirement as to a particular format of a loan documentation. So the loan agreement itself is a contract. So it's governed under the contract, the law of contract. So how does a structure of a contract? It will depend on the kind of documents required for that particular facility. In Malaysia, most of the loan documentation are mainly standardized by the bank or financial institution. So as we say, for the loan agreement is on a contract basis. So the general principle of the law of contract is that when there is an agreement to grant a facility, such facility cannot be withdrawn after the offer was made and accepted by the borrower. In other words, in the event the latter offer has been offered by the lender and accepted by the borrower, it constitutes a contract. So the lender may be liable for a breach of contract in the event the lender doesn't want to proceed with the offer. Whereas if there is a conditional offer letter issued by the banking facilities and it has been accepted, as long as it is a conditional and a formal agreement has yet to be executed, a valid contract has yet to be formed. Similarly, if a letter offer contains a conditional conditions to be fulfilled, or containing some terms and conditions which is not complied with by the borrower, and a loan agreement has not been formally executed between both parties, it is not a concluded contract as well. So what does it mean, a security? Security are basically something where the creditor can rely on and can realize the security for the recovery of debt in the event there is a default by the borrower. Generally, there are 5 aspects which the lender have to consider on what type of security is considered a good and adequate security for a loan or credit facility. Firstly, is the value of the security. It has to be capable of being ascertained without much difficulty, and such value must be consistent over the years. Secondly is a test of acceptable security. This is what we call realizability. The lender will always consider how easy can the security be sought in the event of default. Thirdly is on the validity of the title. The title to the land or the property should be perfect and unquestionable. Similarly, it has to be indefeasible. Indefeasible meaning it does not subject to any dispute by a third party, which may have a claim over the security. So usually when we do conduct a land search on that property or land, the land search itself will reveal should there be any private caveats, landholders caveats, registrar caveats, which has been lodged over the title. So in the event there is other encumbrances on the title itself, it may affect one of the aspects that the lender may want to consider whether to accept that security as one of the collateral. Lastly, in granting a loan and facilities by the lender to the borrower, the lender will always also step into the shoes of the borrower to think in the borrower's point of view. So usually all costs of conveyance, charges, documents, stamping costs, legal costs are to be borne by the borrower. So from the lender's point of view, these are the 5 general aspects that the lender will consider before determining a security which is adequate, good, or legally sound. Yep. These are the general securities required and accepted by the bankers and financial institutions. So let's move on to the first one, which we are more familiar with on the real estate, land or property as a security. When we talk about property, lands as a security, the first thing in governing the law in Malaysia would be the National Land Code. Bearing in mind, National Land Code is only applicable in West Malaysia. So in East Malaysia, any dealings in land pertaining to the property land in East Malaysia, Sarawak, they have the Sarawak Land Code. For Sabah, they have the Sabah Land Ordinance. So generally, land law in Malaysia, we adopt what we call is the torrent system. So the basic principle underlying the torrent systems is that all dealings in land must be registered in order to be effective. Registered and effective. Okay, I will go on charges, liens, and assignments. So in determining how can it be registered and to be effective in Malaysia, in the event the property with individual or strata title, or the property is, the title is yet to be issued, there are different procedures, different documents, the procedures, documentation are different. When the title has been issued, then we will go on the land charge. But when the title has yet to be issued, there will be an assignment process. So let's go on the charges first. When the title has been issued, the lender will require the land to be charged and registered in favor of the lender. So charge is to secure for a repayment of a debt, and it is also a predominant form of security taken by the bank when financing the purchase of development of land or property. So chargee here will be the lender that will acquire a legal interest in land, whereas the charger will still retain the ownership of the land. So chargee can enforce the security by way of sale if the charges default. For a charge to be registered in favor of the lender, it has to follow the instrument in accordance with the National Land Code, and then it has to be presented with the land office or the registry for registration. And that charge has to be lodged with the Company Commissions of Malaysia, our CCM, within 30 days from the creation of the charge. This is applicable to the company if the company is the borrower. So statutory liens. Statutory liens is also one of the security prescribed under the National Land Code. So similarly, on the lien itself, it has to be registered with the land office. So liens holder caveat can be entered by the caveator, the liens holder. Unlike a private caveat, liens holder will continue to succeed until it is withdrawn. Unlike the private caveat, it has an effective lifespan for only 6 years. So it is prerequisite in order to enter a liensholder caveat. The registered owner, it has to have intention to create the lien as a security for the loan, and the registered owner has to deposit the original title with the lender, and thereafter the lender can apply for the entry of liensholder caveat. Yep, the entry of liensholder caveat is also by a prescribed form under the National Land Code and to be lodged with the Land Office. Assignment, yeah, as we say, they are property when the title has yet to be issued. So by way of assignment is an absolute assignment of the borrower rights, title, interest in the sale and purchase agreement in favor of the bank. This happens usually when the bank is financing the purchase of the land or property, when the issue documents of title has yet to be issued. For the documentation, assignment itself can be perfected by serving a notice to the counterparty to the sale and purchase agreement. If the property is purchased directly from the developer, a notice is to be served on the developer. Sometimes the developer may require consent to be obtained prior to the assignment. So if that is the case, consent shall first be obtained from the developer. If it is a sub-sale matter, then the notice to be served on the vendor. Coupled with the assignment, usually there is a deed of power of attorney. A power attorney given the power to the assignee to sell, assign, deal with, and take possession of the property. That deed of power attorney has to be registered at the High Court. So the next most common forms of security to be given by a company borrower would be debenture. So other than we talk about the fixed land charge, debenture can be an additional security or a security required by the lenders. So debenture is a charge over its other assets, which is tangible or movable assets. It can be your plant, machinery, equipment, furniture, motor vehicles, book debts, stocks, raw materials, or other goodwills as a security, depending on the nature of the business or the company. As we know, debenture is also is a charge in writing, is an agreement as well. But in debenture, we are classified into two types, whether they are fixed charges or floating charges. So if it is a fixed charges, it has an immediate effect of appropriating a specific assets to the satisfaction of a debt in the event of default. Fixed charges are those things that they are attached to the company, like machinery, your plants, equipments, whereas floating charges are those things like it is allowed to be dealt with by the company in the ordinary course of business. Until some event of occurs, when like event of default, that floating charges can be crystallized into a fixed charge. Floating charges are floating assets, as if your stocks, your goods, your stock in trades, that can be dealt with by the company in the ordinary course of business. So until crystallization of the charge, the charger company can no longer deal with the assets. So these are what covered under the debentures. Yeah, formality-wise, as we say, is an agreement, known as debenture. And debenture also has to be lodged with the CCM within 30 days from its creation. Next one that we are familiar with is guarantee. So when we talk about guarantee, it can be given by an individual or a company. So guarantee is to serve and enhance the creditworthiness of the borrower, and it is also as an expression of confidence in business and management of the borrower and their commitment to ensure the borrower repay its debts. Guarantee is the most common form of security, or we can take it as an additional security on top of the land charge or debenture. In most common form of guarantee right now required by the lenders are in joint and several guarantee, meaning the remedy is cumulative until the whole debt is recovered and satisfied. What does it mean, cumulative? Meaning to say that the lender always have the right to proceed with legal action concurrently against all the guarantors for the recovery of debt. Guarantee is also a contract, is an agreement. So agreement can be signed by individual, or it can be signed under the seal of the company and to be witnessed. So in the event it is a corporate guarantee, a guarantee given by the company, we would require a director resolution authorizing the giving of the guarantee and specifying who are the authorized signatories to sign on behalf of the company in giving such guarantee. Yeah, I will slightly touch on some issues in respect of guarantee that we usually come across along the guarantee period. So firstly, on the variation of guarantee. So you see, should there be any variation to the terms of guarantee? You see, guarantee are usually given by the guarantor, and there will be a principal debtor, meaning the borrower, and the creditor. So should there be any changes to the facilities, whether the variation is substantial? If let's say the variation is unsubstantial, it may not prejudicial to the guarantor, then the guarantor is not discharged by such unsubstantial variation. But then where there is a material variation, such variation, if let's say it is prejudicial to the guarantor, it will discharge the guarantor from its obligations. So how do we deal with it? In the event there are substantial variation, it's always good to get the consent from the guarantor to avoid any dispute in the future. Although in our current banking systems, the bank's guarantee are usually having this clause, they call it continuing guarantee for indebtedness. They usually include a term which was defined to include all principal sums and other monies, whether actual or contingent, now or hereafter, from time to time, and any time owing to the 20th year is to the bank by the borrower or remaining unpaid to the bank by the borrower. Such guarantee then executed, guaranteed the payment of monies lent thereafter. So if we include these clauses into our guarantee, it means that it will include the grant of facilities in the future. So meaning to say, if you sign the guarantee dated today, it doesn't mean that your guarantee sum is fixed. It will cover all the amount to be granted by the lender to the borrower in the future. So with this, a variation in the facility may be effected by the banks, but plaintiff without discharge of the guarantor's obligations. I'm quoting a High Court case, the principle underlying a High Court case here. Yeah. So in some aspect, when granting a loan, we see the lenders may require a letter of comfort, letter of awareness from the shareholders or from the directors. Why do we need a letter of comfort or letter of awareness? So bearing in mind, letter of comfort and letter of awareness is not a guarantee. Yeah, but we always look into the constructions on the wording itself, under which the intention of parties in giving such letter of comfort and letter of awareness. Letter of comfort are usually served as a statements of moral responsibility. So it is not intended to have a legally binding effect. It's more like a comfort. So I'm looking into a Court of Appeal case. The principle underlying this letter of comfort is whether capable of giving rise to a legally binding undertaking. It depends on the intention of the parties and the circumstances under which the letter of comfort is given. So it always falls back to the contents of the letter of comfort or letter of awareness. And we don't look at the heading itself, we don't look at the title itself. We look into the party's intention when giving such undertaking. Yep. And then the differences between the guarantee and indemnity. It can be combined, it can be separate. Sometimes we have a guarantee plus indemnity. Yeah. But in some cases, we can have a separate guarantee and a separate indemnity. Under a guarantee, the definition in the Contracts Act is that in a usual guarantee, it has to have three parties involved. That is a surety. Surety is the guarantor. Then we have a principal debtor is the borrower, and the creditor is the bank or lender. So by right, in an indemnity, anytime indemnity can be given by only two parties, two persons, one indemnify the other one. So in the constructions of a documents, whether it is a guarantee or is an indemnity, the court is not bound by the label affixed onto the particular documents. Yeah, in the federal court case, the duty of the court is that to construe the document as a whole and to determine from its language and any other admissible evidence its true nature and the purport. As we said, law always look into the intention of the parties when construing the documents. Yeah, I see some requests on the bank guarantee. Actually, the bank guarantee is given by the bank. So it's a form of security given by the bank. So I just have a brief one on the bank, on the BG here. So BG is commonly used in the trade finance facilities. The instrument that we call is bank guarantee, is a BG. So BG is a guarantee from the lending institutions, ensuring the liabilities of the debtors will be met. So yeah, this is usually when we use in trading trade lines to secure the obligations in for the parties' contract. For BG, the formality here is the principal will be the party who requests the guarantee to be issued. They will apply to the bank for a BG to be issued in favor of beneficiary. So here, beneficiary will be the party who received the guarantee, who received the payment at the end of the day. So by issuing the BG, the bank offers a security to the beneficiary that is separate from the principal liability and will to fulfill his part of the contract. When it comes to fulfill his part of the contract, it doesn't mean the secure performance under the contract on the bank side is not on the non-performance, but instead the bank's duty is the payment obligations. So the banks will undertake to make payment upon the BG is issued in favor of the beneficiary. So upon delivering of the performance of the contract, the beneficiary can claim against the bank under the BG. So other miscellaneous securities that we can talk about are like cash deposits. These are quite common nowadays. So cash deposits is like pledging your fixed account, your FD account. So in charging and assigning to the bank's account that contains a deposit in favor of the lender or the security holder. So when the lender is an account bank, yeah, the bank will usually have a right to set off, yeah, in respect of the deposits. So it always come together. If you have a memorandum of deposits, the banks will also require a letter of set off. So same thing, this one has to lodge with the CCM as part of the security as well, within 30 days from the creation of the charges. Subordination may happen when it comes to a larger amount of loan. Subordination of the shareholder existing creditors' debts in respect of the priority of debts. Directors and shareholders' advances are subordinated from the current facilities granted by the lender. Usually, if the amount of loan if the larger amount of loan or the loan amount are substantial, the lender may require a letter of subordination to be executed by the existing creditors. But most common one is a letter of subordination to be executed by the directors and shareholders, that should there be any advances made by the director and shareholders in terms of repayment, recovery of debts, their rights will be subordinated than the existing lender in that current facility. Another one that I will just briefly go on the insurance policies. So sometimes in terms of bridging finance also, the lender may require those insurance policies which are applicable to the building machineries that to be insured in favor of the bank. So sometimes they will have this, it's kind of absolute assignment as well, one of the additional securities that the bank may require in the event the loan are substantial. So my third part of the discussions on the releasing of security. Releasing of securities upon full settlement of the loan sum. For charges, the real estate side, it will be a discharge of charge under the prescribed form in the NLC. So at the same time, when the loan has been fully settled, we will request the to have a process for discharge of charge, and the title should be returned back to the registered owner upon full settlement of that. And then we are also required to file a memorandum of satisfaction of charge with the CCM. That is under the Section 360 of the Companies Act 2016. For liens also, there is a withdrawal by the liens holder caveat upon full settlement of the sum. yeah, that is when it comes to a situation that is that you have a lienholder caveat can be withdrawn by the caveator, by the registrar, or can be cancelled by court upon applications. When there is an assignment created upon settlement of the sum, we go on the process. The rights are all same. It's just the documentation will be a deed of receipt and reassignment. If we assign all the rights, interest, title under the sale and purchase agreement from the assignee back to the assigner upon full settlement of the loan sum. At the same time, usually they come with a power of attorney. So your power of attorney, once registered with the High Court, you have to revoke it. And then similarly, the same thing, you have to lodge a satisfaction of charge with the CCM Malaysia. Debenture, the same thing as well. It can be cancelled by discharge of all monies obligations under the debenture upon full settlement of the loan facilities. Yeah, same thing to lodge a satisfaction of that with the CCM. Yeah, guarantee is a contract, is an agreement. So once it has been fully repaid by the borrower, the guarantee will be terminated or determined. Yeah. My last part will be on the enforcement of securities. Yeah, how does securities being enforced for the recovery of the debts in the event they are default by the borrower? So for the real estates, land or property, we have a charge. If let's say there is a land charge created and represented at the land office, yeah, the proper procedures is to foreclosure proceedings. The secured creditor can get an order for sale that will be based on the title. You'll be the court order is either from the court or an order for sale from the land office. So the property can be sold by public auction under an order for sale granted by the court or the land administrator. Yep. To enforce securities under the liens, a judgment from the court must be first obtained before the property can be foreclosed. So it's the same thing after we get an order for sale, the property can be sold by way of public auction. Yep. Enforcement of debenture can be done by way of appointment of receivers and managers to manage the affairs of the company for the benefit of the debenture holder. Appointment of receiver and managers can be done by the company, can be appointed by the shareholders, directors of the company, or a debenture holder. In some situation, it can be appointed by the court upon order of the court being obtained. In that scenario, sometimes when the companies are not doing well, when there are some issues in terms of the assets, the dispute on the assets, so a court order may be applied by the shareholders, directors, debenture holders, yeah, in order to get the R&M to be receiver and managers to be appointed to avoid to safeguard and preserve the company assets to be dissipated. So there will be there will be an order from the court to ensure that the assets of the company are not dissipated, yeah, by any of the other the directors or any of the management of the company. Yeah. So you see, R&M are different from liquidator. They have the same qualifications, but they are different. So the power of R&M is to carry on the business as usual, yeah, to manage the affairs of the company. So the powers of R&M will only cease until the company is wound up and with the appointment of liquidator. Yeah, in terms of guarantee is an agreement. Guarantee is an agreement to pay money on the borrower's default. So the liability of the guarantor are expressed to be payable on demand, and the standard is a usual notice of the lender by giving a letter of demand to the guarantor. So in the event they are default by the borrower, usually the process that the lender can do is to issue a letter of demand, then go on the usual court process, meaning you serve summons, then you get a judgment before you can enforce against the guarantor. Yep. Cash deposits is relatively easier because usually if you have a fixed deposit account maintained with the lender has a memorandum of deposit with the letter of set off. They can exercise his right of set off set off under the letter of set off and the memorandum of deposits. Yeah, that's all for my sharing today.
Thank you, Ms. Teo Siang Lee, for the enlightening sharing on lending and securities by financial institution. I'm sure it is very helpful to many our attendees today. So now we have come to the Q&A section for this webinar. You may post your question in the chat box if you have any question. Before we go on, I would like to share the questions which has been posted. So the first question was posted by Sydney Wong from Halim Hong and Kwek. Her question is, do we use the same Form 42B satisfaction of charge form for non-property or land, for example, OD or FD, as the SSM forms mostly related to land or property?
All right. To answer Sydney's questions, there is only one prescribed form under the Companies Act. Last time, I think prior to 2016, it was a Form 42B. Right now, the satisfaction, the memorandum of satisfaction of charge is under Section 360 of the Companies Act. So be it you are releasing a security for debenture, for land, for assignment, there is only one statutory form, the same form under the Companies Act.
Thank you, Siang Lee, for answering the first question that is posted by Sydney. So now we come to our second question. This question is posted by Chua Siu Kiat from Ban Sing Gua Senjam Berhad. So the question is, in the debt layer of the capital structure, there is different seniority of the debt, meaning they get paid in different order. In an analogous reasoning, can one structure a loan guarantee with multiple guarantors, such as corporate guarantor A, personal guarantor B, personal guarantor C, and etc., with different seniority in such a way that in the event of default, the lender may have to exhaust all means with guarantor C, then guarantor B, then guarantor A?
In answering Chua's questions, firstly, you see, the guarantee is an agreement, so it can be structured in any way as long as the terms and conditions are agreeable by both parties, meaning the guarantor and the lender. So, but looking at your proposal on structure, you see, you said, if let's say, can we do it in a structure that we want the lender to exhaust all means to C first, the guarantor C first, before you go after guarantor A and B? Okay, as I can see here, if let's say to exhaust all means, meaning to say, under an agreement, we have to serve a letter of demand against the guarantor C, then you have to serve summons, you get a judgment against C. After you get a judgment, it's a paper judgment. You have to enforce it. In terms of enforcement of judgment, there are various modes. You may have your writ of seizure and sale, if you know there are properties. You may have a writ of possession. You may have a debtor's judgment debtor summons. You may have other garnishing proceedings, if you know they have the bank's accounts. And lastly, you may go on bankruptcy. So in terms of exhaust all means against C, there are various modes of executions that the lender has to do. So by imposing this kind of terms and conditions, it imposes a superfluous obligations on the lender. Yeah, and taking into the cost incurred by the lender, yeah, to us, in terms of recovery of debts, to the lender's point of view, it has to be fast and it has to be safe cost, the lesser cost that the lender can incur. So to this structure, to my point of view, is unlikely a lender can agree to this structure. Yeah. Another way to consider, you may want to have a limited guaranteed sum. You may want to limit the guarantee sum by each guarantor. That would be another alternative that the lender can think of. It's fair to the lender. So to this structure, unlikely to most of the lender, I don't think it can be agreeable by the lender. Yeah, I hope I answered your questions, Chua.
Thanks, Siang Lee, for answering Chua's question. Now we have another question from BB Chu. The question is, if SPA being terminated and purchaser not agreeable to pay the cost for the R&R and revocation of PA, what action can be taken?
SPA, a sale and purchase SPA has been terminated, then the purchaser refused to pay the revocation. The R&R is I believe you sign a sale and purchase agreement and a deed of mutual covenants. So when it comes to revocation, you see, if a purchaser wants you do not intend to purchase, how can you let the SPA just leave it like that? Yeah, anyhow you want to revoke it, right? This is to protect your interest. If your SPA without a revocation, it is a valid contract. So the agreement are still subsists over there. Over the years, it is still an agreement. So if you don't sign the revocation, then the developer or the seller, they have the rights to go after you and ask you to perform the SPA. So I don't really see what is the issue here. If let's say the purchaser refused to sign to pay the cost, meaning the SPA cannot be terminated, there is no revocation. So the purchaser is bound to fulfill its obligations under the SPA. Yep.
So looking forward to our next question. This question is posted by Brandon Mui. The question is, can a collateral be charged to multiple lenders?
Yep. A collateral can be charged to multiple lenders subject to whether your existing facilities, your existing loan agreement has restrictions that the subsequent charge are subject to the consent of all the existing lenders. You see, most of the loan agreements right now, we have banks has the first right of refusal. If you're having a current facilities, you charge the properties to the bank. In the event you want that property to be charged to the next bank, you have to get a prior consent from your existing bank. Yeah, unless there's no such restrictions, depending on the collateral, unless you don't have such restrictions. But I see most of the facilities would have such restrictions. It's called negative pledge. Yeah, in your letter offer, in your loan agreement. So always have to get a consent from the existing lender before you can charge to your security to the next lender.
Thank you, Siang Li, for answering Brandon's question. So if there is no other question, then we may move on to end this section. Right. So before we end this section, kindly be informed that an evaluation form will be sent to you via email, and we look forward to your feedback on our webinar on lending and securities by financial institution today. I believe that's all the time we have today. This marks the end of our webinar. Thank you very much for joining us.
Thank you for all your time. Thank you for all the participants. Take care and stay safe. We shall see you again.